on the record in the matter of Ali Elbast versus Kurt Reed. This is 25-07066. Please. Upstairs right now. Cover your parents, please.
Yes, Sierra Oliver, P87707 for the defendant.
Okay, and you're Mr. Ali Elbas?
Yes.
Okay, very good. And you're Mr. Kurt Reed.
Yes, I am.
Okay, this matter was scheduled today for a hearing. I have here a consent order for conditional dismissal. It says that the matter will be dismissed upon the condition that you agree to the following past due rent amount of $5,840 plus court costs of $150 for a total $5,990. That's for rent through a period ending of February 28th, 2026. It says that on or before February 14th, 2026, defendant shall pay $2,500. On or before February 28th, 2026, defendant shall pay $300. In the beginning of March 2026, defendant shall pay $200 per month due by the 5th of each month until the past due balance is paid. Beginning March 2026, defendant shall make timely rent payments, no late fees to accrue if defendant makes timely payments. Plaintiff shall accept a promise to pay by a third-party agency that agrees to timely pay all or part of defendant's balance. That's complete and accurate?
One question.
Yes,
I
sir.
just started receiving my retirement, and the document I received from Social Security, it states that I receive the fourth Tuesday of every month. That's why it was the date of the 28th. I just wanted to be clear with that. So if I am, if for some reason the mail's not running or whatever, I'm a day or two late, I don't want to check by it.
Oh, 28th on Saturday.
Of this month,
Okay.
but not every month.
It says that you're gonna make a payment on the 28th of this month, and then after that, it just says March 2026. Doesn't even say a date.
Okay, I just wanted to clarify. Thank you.
Okay. Do you have any other questions at this time?
No, ma'am.
Okay. You understand that you have the right to proceed to a jury trial in this matter?
Yes, I do.
Do you want to waive that right?
Yes, I will.
Anyone coercing you to do that?
No.
Okay. You understand partial performance is not going to satisfy this, so you have to do exactly what you said you were going to do here in this agreement if you want this matter to remain dismissed. If you don't comply, the plaintiff can request to have the case reopened, judgment entered against you. You will not get a new court date for that. You understand that?
Correct.
Okay. You have 3 business days from today's date to return to the court to request to have this set aside. If once you leave here, you realize that you misunderstood any of those rights, okay?
Thank you.
Do you have any questions at this time?
I don't.
Any additional matters for the record?
Thank you.
Thank you. Anything?
You have a great day.
Same to you. We'll get you a copy of the paperwork in just a moment.
Thank you very
Okay.
much.
I just did cover your document. Okay, so have we seen the one, the other 8:30?
Oh, Woody's out there. She's
On that side. This one? The Beers West. I didn't know they had filed any ones, but they just. They filed what?
Dearest West, I think he signed something, but I didn't know that.
Oh, Dearest West is here, okay. Second. I'm not sure. They didn't send an email or anything. It just appeared to me. That's the attorney for this?
Yes.
Indon Point Apartments versus Dieris West 25-07471. Appearance, please.
Eric Holt on behalf of the plaintiff, Your Honor.
Your name, sir? What is your name?
Oh, Dearest West. I'm sorry, Your Honor.
Today was the date scheduled for a hearing. You all resolved this?
We did, Your Honor. We have a consent judgment to place on the record.
Okay, you can put the terms on the record.
Thank you, Judge. Mr. West and I have agreed that he owes rent through February of $7,600, court costs of $181.54, for a total of $7,781.54, with a writ date of February 16th, 2026. Mr. West has had the opportunity to review that proposed consent judgment and has signed it digitally. It's my understanding he's got significant income tax refunds coming, Judge, within the next 21 days, and intends to take care of the debt.
Mr. West, is what the attorney saying complete and accurate as to your understanding of how you want to handle this?
Yes, Your Honor.
Okay, so you understand that you have the right to be represented by an attorney at this hearing today?
Yes, Your Honor.
You want to waive that right?
I'm sorry. What was
Do you want to give that right up, or do you want to get an attorney?
it? Give that right up.
Okay, you also have the right to proceed to a trial. You could demand a jury trial in this matter, or proceed to a hearing. You want to give up your right to have a trial as well?
Yes, Your Honor.
Is anyone coercing you to give up these rights and enter into consent judgment?
Correct, Your Honor.
Did you hear my question?
Oh, no, I'm sorry. My phone's gonna.
You said correct. I said, is anyone
What was that?
coercing you? I asked you if anyone was coercing you to enter into consent judgment. You said correct.
Oh, no, Your Honor. I'm sorry.
Okay, yeah, a partial performance will not satisfy this. You have 3 business days to return to the court. If once you leave here, you realize you misunderstood the rights that you waived, you can request to have this agreement set aside, okay?
Yes, Your Honor.
Did you give Mr. Holt permission to sign the consent judgment on your behalf? Or did you
Yes,
sign
Your
it
Honor.
already? Okay.
I
Any
signed it.
additional-
I signed it last night. It was a paper form that I was given on my email
Okay,
through my
very
email.
good. Very good. Any additional matters for the record?
No, Your Honor. I've submitted that proposed judgment via my file moments ago.
Okay, I was gonna say I haven't seen it yet, but okay, thank you.
Thank you, Judge. Thanks, Mr. West.
Yes.
Thank you. Have a good day. Do I just touch leave?
Yes.
Oh.
Michael Lockhart is here. Did you all resolve your matter?
We did, Your Honor.
Okay, how?
With a
On the record, in the matter of the Brick Property Ventures versus Michael Lockhart and all other occupants, 25-07510. Council, give me your name for the record.
Certainly. Good morning, Your Honor. Nicholas Darling, house number
And your
72150.
name, you can step up here because I want them setting up, because I gotta call a jury in here. You all step, both of you all
Yeah.
step so that they can sit down and set up.
Sorry.
Thank you. Okay, your name, sir?
Michael Lockhart.
Okay, today was the date scheduled For a hearing for non-payment of rent. I do have a consent order for conditional dismissal. Says you're gonna agree to pay the past due rent plus court costs, total amount $4,977.34. That's for rent through a period of February 17th, that you agree to pay $800 on or before the 18th. And the defendant agrees to vacate the premise on or before March 18, 2026. Is that accurate?
Yes,
Okay. You understand that you have the right to have an attorney represent you?
yes,
Do you want to waive that right?
yes,
You have the right to proceed to a trial, or you could have had your hearing today, and you understand that.
yes,
You want to waive that as well?
yes,
Anyone coercing you to waive these rights?
no,
Partial performance will not satisfy this. So if you don't vacate by the 18th of March, if you don't pay the full amount that you say you were going to pay by February 18th, then the plaintiff can request a judgment to enter against you. You will not get a court date. You understand that?
yes,
You have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood your rights, you can return and request to have this set aside, okay?
yes.
I will get you a copy. Any additional matters for the record?
Nothing for me, Your Honor.
You're all set.
Thank you.
No problem. On the record, in the matter of Jamonte Gates versus, I'm sorry, State of Michigan versus Jamonte Gates, file number 25-01987, appearance.
Kim Buckingham for the people requesting a practice under 8.120 under supervision of Assistant Prosecutor Haley Fortuna Gill.
Permission is granted.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Gates, who's sitting to my right.
Okay, today was day 2 for jury trial. The jurors are all here. We're scheduled or ready today to proceed with final arguments or closing arguments. And then we do need to do composites. Correct?
Yes, Your Honor.
Should go over composites now before we bring them, and I have not sent them, so let me send them now. And that way you can tell me if I'm missing something or if you would like something added.
Yeah.
Sorry.
You okay?
Mostly to Addie, I just scared they have like little things.
I'm looking for that. So please. So is it there?
David Carter. No. Oh, no, I've had Charlie and Susan. Oh, okay. I didn't know that. Oh, okay.
You got it. Yes. Did you all get the deposits?
I just, it
We just got it.
Seymour Group versus Love must have been dismissed.
Versus what was the last name?
Love. Yeah, I see that this one's on.
It's
Look at the mirror on it.
Thank you.
fast readers. Like, I'm on slide 25.
Any changes for you, Ms. Sutter?
Yes, sir. I think two should be added, 720 and 722.
Lauren, can you repeat that?
720 and 722. 720 is burden of proof for self-defense, and I guess 722 is self-defense.
Yes.
Anything else?
I don't think so. for
Isn't
myself.
it the 17? I think it's in there. Is that definition? Or is it-
There is a definition of defense protection. That's a construction. Yeah.
Which one are you looking for?
Offensive touching.
That wasn't that in the?
I thought it's in the assault.
Isn't it a subsection in the 17-2A?
I think we read it in the procedural. let me see.
Yeah, okay.
Then we should be all set. Unless you have anything.
Yeah, it's defined in 17-2A. It's subsection.
Is defendant not testifying?
Isn't my initial ones?
It's not.
I added it in here yesterday.
Okay.
Did it not testify?
How about 4.1 defendant statements as evidence?
3.3 is not, however.
Okay.
At least I don't see the PowerPoint slide. Oh, they're out. Okay, I'm sorry. They're out of order.
Okay, we're all set.
Okay, yeah. Okay, so you just needed those two added. Nobody need anything else? Any other matters before we call the jury in?
Not for me.
I don't believe so.
Where the jury in?
All rise.
Okay, you can be seated. Thank you. And thank you for being so timely in your return today. We have closing arguments that are going to happen. I'm going to give you some final jury instructions, and then you'll be free to go and do your deliberations. So you can start.
Just here, so not too close to you guys. Great. Thank you so much for your careful attention throughout this whole trial. I'm sorry we had to call you back for a second day, but hoping we can get you out of here fairly quickly. When you go back to deliberate, your job is not to decide if this relationship was healthy, if the breakup was messy, or if it was wise of Michaela and Mr. Gates to stay under the same roof, given the circumstances. What I want you to remember is the reason you're here is to determine whether or not Mr. Gates touched Michaela, the mother of a shared child, in an offensive way without her consent. The evidence showed beyond reasonable doubt that he did. Let's start with what isn't disputed. Michaela is a Matus, and Dermonte Gates shared a child, shared a home, and shared an on and off relationship for years. Even after the relationship ended, Michaela was still living with Mr. Gates, relying on him for housing and stability for herself and their child, as we heard in her testimony. This context matters, not to gain sympathy or to make any excuses for any arguments that occurred, but rather to understand the clear power dynamic between them. Let's talk about July 1st. Mr. Gates and Michaela had been arguing. Arguments happen, especially given the context post breakup, and honestly, they're inevitable. We heard that Michaela was nagging, admittedly, Mr. Gates that night. Arguments are allowed, but what isn't allowed is crossing into the use of physical force. We heard testimony from Michaela that she went to Mr. Gates' room to talk, again, admittedly to nag him. She was upset with how he had been interacting with her, and she wanted to deal with it right then and right there. But Mr. Gates wanted her to go away. And rather than disengage or leave the room or even call the police in that moment if he felt threatened, in that moment, he decided to take the situation into his own hands. And he chose to put his hands on Michaela and throw her out of the room. That's our first instance of battery, but it didn't end there. We heard that after that first shove, she got up, shocked, and came back and reopened the door. We heard from Michaela that there had never been an instance like this before with Mr. Gates. She was in a state of shock that had just happened, and there was an error in her testimony of she came back to say, what the heck was that about? We hear that as she opened up that door again, she was grabbed harder that time and pushed across the hall again. We heard from defense's witness, Mr. Kraft. Mr. Kraft was not at the home to help in the prosecution of Mr. Gates that day. Admittedly, he was pretty neutral to both sides. He was there to help his son, Nicholas, roommate in front of Mr. Gates, with the AC. He was staying at the house, and he started out somewhat minimizing the interaction. However, even in that slight minimization, Mr. Kraft still gave a definition of battery. From the couch, he heard banging. He heard the defendant say, "You can't be in here, you've got to get out of here." He saw Mr. Gates place his hands on Michaela and push her out of the room and then close the door, force causing a movement that resulted in Michaela's body crossing the hall. Even if it's not what he'd call it, it's what the law defines battery as. And here's something really important I want you to remember when you go back to deliberate. What did Michaela's testimony, Mr. Kraft's testimony, and even the testimony out of the defendant's mouth in the body-worn camera footage from Officer McGregor all have in common? They all acknowledge that at some point there was a shove of Michaela. Pushed Michaela. And what did Mr. Kraft say? He said Mr. Gates pushed her out of the room, and even in Mr. Kraft's testimony is consistent with what Michaela said. I'd like to remind you of the noise that Mr. Kraft said he heard, as if a door closed or something hit a door. This is completely consistent with Michaela's testimony. Whether it was a door shutting or something hitting a door, that door was shut, she went back and was pushed again. And I'd like you to also recall the physical motions that Mr. Kraft made while he was testifying. When asked how that grab looked or that shove looked, he put both hands on both sides of who would be Michaela, and he did a pushing motion. That's consistent with what we saw in the injury pictures of the bruising. Now, I won't pretend to know how much Mr. Kraft truly saw in that moment. I also don't know at what point of the assault he saw this interaction. It was dark, he was in the living room, he was looking down a hallway, and he was looking at two people that he said he hadn't even noticed were there that day. So I won't maximize what he saw at what point, but what I do know is that what he heard and what he saw is consistent with Michaela's testimony. That unwarranted touching by itself is sufficient to amount to battery. But you know what else we have to supplement that grab is the pictures taken the next day. And you'll be instructed by the court that the law says injury doesn't have to occur for a battery to have taken place. That contact right there is enough on its own, but we do have an injury. We have those pictures. We have the finger marks under the arms of where you would have been grabbed. And we also saw that scuff on her hand, likely from rubbing on something during that interaction. You heard about how Mr. Gates didn't want Michaela in his room and how he didn't want Michaela to call 911. We heard that out of his own mouth in Officer McGregor's body worn camera footage. We saw him talking to the officer, and we heard Mr. Gates say he didn't want police to be called. He told Michaela she was not calling the police. And then he said, fuck it, and he went to bed. He almost did a resignation type motion when he said that. And I would like you to consider that that is inconsistent with fear or self-defense. It was about who gets to decide who goes into the room when discussions occur and the tension that culminated in this physical assault. A moment of irritation bubbling over and manifesting into that physical force of get out of my room. This case isn't about a relationship failing and why. It's about a moment where hands were used instead of words, and where power was finally shown through physical force on a day where the bickering became too much for Mr. Gates. The law doesn't allow that in any home relationship context. For those reasons, we ask that you return the only correct verdict, that Mr. Gates is guilty of domestic violence beyond reasonable doubt. Thank you.
Morning, everyone. Thanks again for being with us the second day. Thanks for your time and attention all throughout yesterday. It was a long and hot one. Hope it's a little cooler in here today. It is to me anyway. The state wants you to believe that this is a case about anger and violence, a young man out of control. I think what we heard and saw yesterday is that it's not. This is, like I said yesterday morning, and in a situation where a young man is trying to protect himself, his boundaries, his personal space where his young son is sleeping late at night. The state wants you to believe that there was this violent shoving from him. What we heard from multiple witnesses, including Ms. Zanitas Raphael, is that she forces her way into the room. We heard from Mr. Kraft, the door was closed. We heard a banging, he sat up, and she's in the doorway. She tells us that she's in there to pick a fight with Mr. Gates after he has repeatedly told her all day, I don't want to talk about this tonight, just drop it, I just want to go to bed. When he comes home, that's exactly what he's trying to do. She's forcing her way through her own testimony into his space at night. Mr. Kraft describes her as wild, angry, forceful, describes Mr. Gates as calm, almost chill, I think is the word he uses. He's tired. It's 11 o'clock at night. He wants to go to bed after a long day at work. He tells us that himself in the body-worn camera we saw from the officer. Michaela likes to tell us that she was forcefully thrown against a wall across the hallway. We see pictures that are of injuries that she's telling us about. We have to ask ourselves, do those pictures match the vision we're supposed to have in our head of her being violently thrown against a wall? I don't think they do. The state also likes to keep bringing up a burn mark on her arm. From what? They never tell us how that might have happened. There's all these missing pieces between the story Michaela has told, the state has told, and between what our eyes tell us and what the only neutral third person in this entire situation tells us. Mr. Kraft was there that night. He had a clear view. He told us. We don't have to guess, minimize, or maximize what he saw. He told us what he saw. He told us there was lights. He told us he wasn't that far away. He said 18 feet-ish. And then he had a clear, unobstructed view. He was not mistaking what he saw. He heard a banging after seeing the door closed. He looked up, he was open, she was there. He saw Mr. Gates move her from the room, close the door. She forced her way back in. He pushes her out and closes the door again. In no part of this is he the initial aggressor. She is forcing her way into his space. She tells us repeatedly she is in the doorway. I pushed her on this. She's not in the room. She's in the doorway. The state says that he should have left the room. She's in the doorway. How is he supposed to leave the room? The only thing he can do is close the door, which is what he does. She forces back in, he closes it again. This is a matter of him defending himself. The state here has a burden of proving him guilty beyond a reasonable doubt. When there's a situation of self-defense, they also have to prove beyond a reasonable doubt it wasn't self-defense. I don't think they've succeeded on either front. If at the end of everything you heard and saw yesterday, you have questions about the story, what actually happened, whether Michaela's version of events is true, you have questions about how all of this came to be, then there's only one fair and just verdict. There's only one verdict supported by the law and the facts, not guilty. Thank you all for your attention.
Just briefly, I'm going to touch on a few things that were just mentioned. We just heard defense talk about protecting his boundaries. The law doesn't allow you to grab someone and throw them out of the room to protect your boundaries. We heard testimony that Aiden, the child, was present within that room at the time. It was his job to disengage in that moment, whatever manner that may be. What we heard from Michaela's testimony was that Mr. Gates did not disengage in any manner. Rather, we heard testimony that he twisted her wrist to grab the phone when she was going to call 911 and held it away from her. We hear this acknowledge this desire for 911 not to be involved in the body worn camera footage of himself out of his mouth stating that he didn't want police involved. And then he ended up saying, fuck it. And then that brings us back to Michaela's testimony, at which point she had access to her phone. This is completely consistent with Michaela's testimony. We also need to talk about the demeanor that was just addressed by defense. A battery doesn't require a wild man to offensively touch someone. They can be controlled, calculated, calm. Grabbing someone calmly in a manner that leaves bruise marks is still battery. We don't need a wild fight occurring. We don't need him screaming at her. That grab with enough force to cause that bruising is sufficient. We also need to talk about opening a door in a house that two people reside in. This act, even banging on a door and opening the door, is not sufficient reason for someone to cause an injury to someone else. In that moment, there was a responsibility to disengage in some manner. That could have been calling the police if he felt threatened. That could have been pushing past her. But instead, we hear, even from Mr. Kraft, that there was a push that resulted in Michaela being pushed out of the door. That itself is a battery. And that is why I asked you to return a verdict of guilty. Thank you.
Okay, ladies and gentlemen of the jury, we have our final set of instructions here on the screen. Okay, members of the jury, the evidence and the arguments in this case are finished, and I will now instruct you on the law as it applies in this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take all of my instructions together as the law you are to follow. You should not pay attention to some instructions but ignore others. To sum up, it is your job to decide what the facts of this case are, to apply the law as I give it to you, and in that way decide this case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable. After a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that was properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence include only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and their arguments, their closing and their opening statements, those are only meant to help you understand the evidence in each side's legal theories. You should only accept the things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, ruling, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to make an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, or whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think that the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about July 1st, 2025 within the city of Lansing, Ingham County. When you go to the jury room, you may take a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. As you discuss the case, you should think about all my instructions together as the law you are to follow. It is your duty as jurors to talk to each other and to make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer who will be just outside the door that you'll be in. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions with you. If you want to look at any of the reference documents or the exhibits that was admitted, particularly because they were video, you would have to ask for that and we'll make sure that you can review them again. When you go to the jury room, you will be given a written copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I have prepared a verdict form listing the possible verdicts. Counsel, did you all see the verdict? objection to that?
No, Your Honor.
The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statements as given to you. If you find the defendant didn't make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case and in deciding if you believe the defendant's testimony in court. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, taking the same example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. When the lawyers agree on the statement of facts, these are called stipulated facts. I don't believe we have anything stipulated to them, so we can skip that. Okay. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. They only have to show that the defendant actually committed the crime and that he meant to do so. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from a witness or witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. The elements of the crime of domestic violence. The defendant is charged with domestic violence. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant assaulted and battered Michaela Zamatis Rethamel. A battery is a forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is not accidental, and it must have been against Ms. Rethamel's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit a battery or to make Ms. Rethamel reasonably fear an immediate battery. An assault cannot happen by accident. At the time of an assault, the defendant must have had the ability to commit a battery or must have appeared to have the ability or must have thought that he had the ability. Second, that at the time, Ms. Rethamel must have been either the defendant's spouse, a former spouse, a person that he had a child in common with, was a resident or former resident of his household, and a person with whom they had a previous dating relationship. A dating relationship means frequent, intimate association, primarily categorized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. Burden of proof for self-defense. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt that the defendant did not act in self-defense. Use of non-deadly force in self-defense or defense of others. The defendant is asserting a claim of self-defense. The defendant claims that he acted in lawful self-defense. A person has a right to use force to defend himself under certain circumstances. If a person acts in lawful self-defense, his actions are justified and he is not guilty of domestic violence. You should consider all of the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. First, when he acted, the defendant must have honestly and reasonably believed that he had to use force to protect himself from the imminent unlawful use of force by another. If his belief was honest and reasonable, he could act at once to defend himself, even if it turns out later that he was wrong about how much danger he was in. Second, a person is only justified in using the degree of force that seems necessary at the time to protect himself or another from danger. The defendant must have used the kind of force that was appropriate to the attack made in the circumstances as he saw them. When you decide whether the force used was what seemed necessary, you should consider whether the defendant knew about any other ways of protecting himself. But you may also consider how the excitement of the moment affected the choice the defendant made. Third, the right to defend oneself only lasts as long as it seems necessary for the purpose of protection. Four, the person claiming self-defense must not have acted wrongfully and brought on the assault. However, if the defendant only used words, that does not prevent him from claiming self-defense if he was attacked. Okay, so one of you are with alternates, so you actually do not have to go deliberate. You can, your number is going to be pulled and you're free to go. Juror number 7. Thank you for your service.
Yeah, well.
Okay, the remaining of you all will be released to deliberate. Again, we'll get you a copy of our completed jury instructions. I need the court officer to swear him in, so. Did you send the updated one? Why you couldn't add 7.3? I don't know where it's jury instructions.
The, I sent him one that,
Did he print them? I don't know. Mr. Worsley, did you print the composites already? If you, I'm just saying, if you haven't, I'm gonna send you an updated one. And if you have, I'm just gonna print the last 2 slides. Okay. Just send those to you. I need to swear you in. Actually, let me send it out of here. He might need to do the book or he takes them. Have a seat in me. Right here. Do you solemnly swear that you will, to the utmost of your ability, keep the person sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise until the time that their service is discharged, so help you God?
I do.
Thank you. Okay, Addie, you can complete the book. I'm gonna have him remove the jury.
okay.
All right, for the jury. We're in recess until the jury has a question, so you can't leave the building. Thank you.
Want me to with you right now or?
Yeah, I think we're about to do LT. Oh, we are doing LT. So there should be some, I saw a couple attorneys peeking in. I don't know if they have resolutions or not.
Okay. I'll go check.
We have hearings in the morning now.
Okay. Yeah, I should do that.
Simply Live, Mr. Whitty should have somebody.
Okay.
Because he dropped this off, so I just need to put it on the record. What's the matter? You can bring it when you bring the book. They can't do anything until they have those instructions. Mr. Brown,
Your Honor.
you are here for the matter with Silver, 460 Silver versus Tashana Hawkins.
Yes, Your Honor. That's going to be a CD. We approved a settlement agreement with attorney Sierra Oliver from Legal Services.
Okay, I did see her, but she's not in the courtroom at this time, so I'll see when she comes back. And then it looks like you have another one.
Yes, I believe that's in person, and attorney Ron Bach is going to be there in person with my client.
Okay, so wait, the one with Leighton.
Yes, Your Honor.
Okay, sounds good. Thank you.
Thank you.
Mr. Woody, you ready on your matter?
I am.
On the record in the matter of Simply Live LLC versus Takar Hardin, 25-07515 LT, appearance, please.
Good morning, Your Honor. Norman Woody, appearing on behalf of the plaintiff, Simply.
Okay, and you are Takara Hardin. Today was the date scheduled for hearing. There is a conditional dismissal here that's been executed. Says the parties agree to have the matter dismissed today.
You want a little background?
I don't need the background. I'm just trying to make sure I read the hair.
You should read my handwriting is what you
Yeah,
really
but,
need.
It's just, it says past due rent, $4,977 plus court costs, $240. For a total of, I think it's $5,217.45, correct?
Correct.
That says for a period of rent through December 31st, 2026.
Should be 25. I thought I corrected
That
it,
was
but not.
another reason why I was like, did I miss something? Okay,
No.
okay, so it should be 2020.
That particular one ended up with more scribbles than usual.
Got it. No worries, we'll get there. Okay, it says defendant vacated on December 31st. Defendant shall pay $50 a week commencing March 1st, 2026, and continue until the balance is paid in full. Defendant security deposit will be processed as provided in the landlord and tenant
Relationships.
Act. Thank you. Since there's no claim to the property. Okay. Let's see. That's how you want to proceed, ma'am? I need you to say it verbally for the record. Okay, and that's correct, accurate, what I read, counsel?
Yes, it is, Your Honor. You did great with my writing.
No worries. Okay, and so Ms. Hardy, you understand that you had the right in this matter to be represented by an attorney? Yeah. Yes. Did you want to waive that right? Yes. You also had the right in this matter to proceed to a trial. You could have made a demand for a jury trial. Do you understand that? Yes. And you want to waive that as well? Yes. Okay, and you understand that partial performance will not satisfy this. So you have to do what you said you're going to do here in section 3, because if you don't, then they can have judgment entered into you, won't get a new court date, okay? Okay, do you have any questions at this time? You have 3 business days to return to the court, and once you leave here, you realize, I really didn't understand the rights that I've given up. You can return to the court, request to have this set aside. We'll set it for a hearing, okay? Otherwise, we'll get you a copy of this in just a moment. Any additional matters for the record?
Nothing further.
Thank you. Mr. Whitty, did you have another one?
I do. That one is going to be.
Kendrick Willis?
Let's see here.
Is LaKendrick here?
The one I was looking at.
Yeah. At 9?
That's a dismissal, Your Honor.
Oh, okay, sounds good.
Willis case.
Okay, so then you have something at 10:15
And I also have, I think,
and 10:45.
yes, on the 10:15 one, I've been talking to Ms. Pereira, and we're going to ask for an adjournment, a short adjournment, not to the week of the 18th, but any other within a week or two.
That's correct, Ms. Pereira.
Yes, Your Honor.
Okay, Willis is dismissed. Correct. Pereira is on the 10:15. Adjourn.
Yes.
In the week of the 18th or
Anything but,
anything except that?
I think that's when Pereira's on vacation.
Yes.
We want her here.
Appreciate
February 25th at 8:30. February 25th at 8:30.
it. Thank you, Your Honor.
No problem.
Yeah. We're hopefully working toward a conditional dismissal on this one.
Wonderful. Thank you so much.
Thank you, Your Honor.
That's all I have for you. Oh, I have a 10:45. Let's see.
Yeah.
Are you on the matter with Mr. Brown?
Yes.
Okay. 460 Silver versus Tashana Hawkins. This is 25-07604. Can I have appearances, please?
Yes, good morning, Your Honor. Chris Brown representing plaintiff.
Good morning, Your Honor. Sierra Albert, P8777 for the defendant.
The defendant is present in the courtroom on which counsel. Today was the date that was set for the hearing. And how are we proceeding?
Yes, Your Honor, we have reached a consent order for a conditional dismissal.
Do you have the terms, please?
Yes, Your Honor. Rent due is $5,287.93. Court costs $181.39 for a grand total of $5,469.32 due through February 28, 2026. Pursuant to the further conditions, on or before the 20th of each month, defendant shall pay $400 until the balance is paid. This is in addition to defendant's ongoing timely rental obligation. No late fees are to accrue so long as defendant makes timely payments. Finally, plaintiff shall accept a promise to pay from a third-party agency that agrees to timely pay all or part of defendant's balance. We have checked for B, waiving notice in event of default. Additionally, I have checked that partial payment will not be sufficient to prevent a writ of eviction of issuing. Finally, Mr. Brown has given me his permission to sign on his behalf.
Okay, that's complete and accurate, Mr. Brown.
Yes, it is, Your Honor.
You can approach counsel. Thank you. Okay, and so Ms. Hawkins, what your attorney read was your understanding of how you want to resolve this.
Yes.
You understand that you have the right to proceed to a trial in this matter, and you could have demanded a jury trial. Do you have any questions about this agreement? You have 3 business days to return to the court. If you later realize you misunderstood the right you've given up, which is a right to trial, you can return to the court and request to have that set aside, okay?
Okay.
We'll get you a copy of that in just a moment. Any additional matters for the record?
Nothing further from the defendant, Your Honor.
Nothing, Your Honor.
Thank you.
Thank you very much.
No problem.
Thank you, Your Honor, and thank you, Ms. Oliver.
Thank
Thank you,
you.
Mr. Brown.
Okay, what's going on with Hunter Town Properties versus Devontae Leggett? That's all of it. Hunter Town Properties versus Devontae Leggett, 25-07534. Appearance, please.
Good morning,
Your name, sir? Okay, today was the date that was set for hearing. This is for non-payment of rent. Did you resolve this?
Yes, Your Honor, we have a conditional dismissal. The defendant is going to be current on or before March 4th.
Okay. That's correct, sir.
Yes, ma'am.
Okay, defendant will be current through February 2026, on or before March 4th. You understand that you have the right in this matter to proceed to trial?
Yes, ma'am.
You could have demanded a jury trial. Did you want to give up your right to trial? You also had the right in this matter to have an attorney represent you, and you've appeared without counsel, correct? And you want to waive your right to counsel? Anyone threatening you to get you to give up these rights? Okay, you have 3 business days to return to the court and have this set aside if you later realize that you misunderstood any of the rights you've given up. A partial performance. Partial performance will not satisfy this agreement, okay? So you gotta do what you said you were gonna do, which is to be current through February 26th, no later than March 4th. Otherwise, they can have judgment entered against you. You won't get a new court date if they do that, okay? Do you have any questions at this time? Any additional matters for the record?
Nothing, Your Honor.
Thank you.
Thank you, Judge.
No problem. Let's not be all blow up. Sir, what's your name?
I'm here for Miss Lake.
You're here for who?
Exactly late.
You're here for him in what regard?
Just relative to this here.
Oh, okay, I'm just trying to make sure we get you in a space where you're not
the
gonna
way.
get hit by the door. Because I'm about to bring a jury back in here.
So you want me to just step out until this time?
Let me clear the jury out and then you can come back.
Okay, cool.
Is Mr. Layton? Because he's not, I seen him yesterday. Oh, okay. Okay, back on the record in the matter of the state of Michigan versus Jamonte Gates. Okay, my understanding is that we have a verdict. So I'm going to bring the jury in. Can you let them know that you can bring the jury in?
I think he's trying to get like a bunch of random people out of that space.
That makes sense. But they don't listen to the sign on the wall that you can't like congregate in the narrow hallway.
I've been guilty. I just, my God, so I'm like, I don't know where people are gonna
I like when you see him go along and stuff.
Yeah.
You can be seated. Okay, my understanding is that you have a verdict. Is that accurate?
Yes, ma'am.
You are the foreperson?
Yes, ma'am.
Okay, you can stand and give your verdict. Yep, just read it.
Does the jury find the defendant not guilty?
Would you want the jury polled?
I don't believe so, Your Honor. Yes, please, Your Honor.
Okay, juror number 1, is that your true and accurate verdict? Juror number 2, is that your verdict?
Yes, Your Honor.
Juror number 3, is that your verdict?
Yes, ma'am.
Number 4, is that your verdict?
Yes, ma'am.
Number 5, is that your verdict? I'm sorry, I talked over you.
Yes.
Thank you. And number 6, is that your verdict?
Yes, Your Honor.
Okay, thank you again for appearing and for being, listeners and attentive and ready to serve. And then coming back for a partial day to get this process done. This process doesn't work without participants like you. Sometimes the lawyers like to speak to the jurors. They can get feedback. You can ask more questions. It's up to you if you want to stay back and talk to them. Otherwise, you're free to go. So thank you again. All rise for the jury. So that will be in a total by way of jury, and we will get you a form in just a moment. Any additional matters for the record?
Nothing defense, thank you.
Thank you.
I was just giving doesn't want to.
You do them good.
Congratulations.
Best of luck.
You didn't want to wait for the form?
Yeah, he does. He's just gonna sit out in the
Oh,
hallway for a
okay.
second.
sounds good. We should have bet.
Okay.
I'm not sure what day.
Yeah, I was gonna say, I don't even know, I think you put the 6th, but
I'm just,
but it's not very legible, to be honest.
I think I
so.
just want
I
this
still
week to
need
be
to sign
done, Your
it,
Honor. Just wishfully thinking that it's Friday. It's my date here.
Is this with or without prejudice?
I think they're gonna charge 57.9.
I wish
Yeah,
we could have last
it's
week.
already been, oh, they're gonna do it in probate court. Okay, this is Lansing 74 LLC versus Kayla Luckett and, is that Corey Luckett?
Yes, Your Honor.
25-07775, counsel appears.
Hey, please, the court, Steve Gann, P 78219 from Plunkett.
And Veronica Pereira, P 79674, on behalf of defendant Kayla Luckett.
Okay, there's another one. It's Amari Richard, but I believe those other two are already defaulted.
Which one do you?
Amiri Richard.
Mayor Richard Yard, we would like to dismiss for that person. That's a minor.
You didn't write it.
It's on there.
And then defaulting Corey Luckett.
Actually, Your Honor, I guess I would, if the court needs, we could do a dismissal as to Corey Luckett. Conditional dismissal as the same terms here.
I can't do a conditional dismissal to Corey Luckett. You can either dismiss or you can get default.
I guess I'll do a default, Your Honor.
Okay.
I'll submit a default after this.
And why has Luckett never appeared to court? Corey. Corey,
Yeah,
co-signer?
yeah.
Why she didn't appear in court? She co-signed, she's got to come to court for an eviction. I told you that at the last court village, if I handled it. I don't know, but nonetheless, there's going to be a default against her, which could affect her credit now. You need to notify your mom that she needs to contact the court within the statutory timeframe to see if she can have that set aside. You understand that?
Yeah.
Okay, let's see here. There is a consent order for conditional dismissal. Says you owe or agree to owe $9,655.10 plus court costs $312.51 for a total $9,967.61 for rent through a period of February 28th, 2026. Correct?
Yes, ma'am.
Yes, Your Honor.
Okay. Says defendant shall pay $1,800 no later than the 6th of February, $1,500 no later than the 20th of February. Defendant shall pay accrued rent on the day it is due and $650 on the 20th of every month toward the arrears until paid off. Amari Richard shall be dismissed from the case. I've crossed out the portion about Corey Luckett because we can't address it on a conditional dismissal. You understand that you have the right in this matter to have a jury trial.
Yeah.
Okay, and are you willing to waive that right to have this matter dismissed with the conditions stated on the record?
Yeah.
Did you all intend to have section 7 selected or not? Because it's not. Partial payment.
Partial payment will not prevent it.
Yes, Your Honor.
Thank you.
Partial payment will not satisfy this. So that means you have to do exactly what you say you're supposed to do, paying on the dates that you say you're going to pay. Because if you don't, and you follow that, then the plaintiff can request the judgment be entered against you. You will not get a new court date for that. You understand that? Okay. You have 3 business days from today's date to return to the court. If once you leave here, you realize that you misunderstood the rights that you've given up, you can return and request to have this set aside, and you'll have to explain how you misunderstood your rights. And then if you're going to submit a default for Ms. Luckett, I need that paperwork as well. Ms. Corey Luckett.
Can I submit that by my file, Your Honor?
Absolutely.
Thank you.
Any additional matters for the record?
Oh, ma'am.
I need a dismissal also for Mario. Nothing else for you, Ms. Pereira?
No, thank you, Your Honor.
Thank you.
I'm here all day, Dan, so I'll get that to you by tomorrow. Is it fine?
No worries. Thank
Thank you. Same thing. Good to see you again, Your Honor.
you. Same to you.
I'm not sure if this is really appropriate in a courtroom, Your Honor.
This is blue country.
I don't know if you want to attack the person that's supposed to be protecting me. I can't feel well. I've never had a court officer actually that was not like a hardcore U of M fan. I don't get involved. That's their personal business. As long as they know that Patriots Nation.
I just-
Also rules in this court.
I'll just never walk in wearing a Buckeye uniform.
Oh, no, that.
Well, how would that be appropriate? You know, that's court attire? Oh.
Well, or anything red and gray.
You can wear, no, you feel free. Your First Amendment rights will not be abridged here. Feel free. Now,
Being a Buckeye is a protected class.
yeah, whatever you all do, I don't know if it's a protected class here in the state of Michigan. Maybe in Ohio. You gotta be safe out here with Buckeyes.
Good luck.
Oh, yeah. Okay. I'll sign that one.
Thank you very much.
And I'll slip you.
Thank you. Be safe. Counsel?
Your Honor, I have a conditional dismissal on one of your 945s. Purchase agreements.
Who is this?
Type Sutton and Jenna Rand.
Is Jenna here?
Yes, she did
Okay.
show up. We're ready on the conditional
Let's
dismissal.
go. I'm ready to.
I'm sorry.
I'm ready.
Okay.
This is the dismissal for minor.
Thank you.
Thank you. Do we know, we gotta find, Mr. Bach with his 10-15.
It was out there earlier. Hey, you got a good one.
You too. No green.
I'm trying.
Okay, this is Sutton versus Rancor 25-07866. Appearance, please.
Good morning, Your Honor. Roger Smith on behalf of Tyke Sutton, who's on my left.
Okay, very good. And your name, ma'am?
Jenna Ram.
You can stand up.
Sorry, Jenna Ramford.
Okay, very good. Today's the date that is scheduled, and this is for a hearing for termination of tenancy. I have here a consent order for conditional dismissal. Oh, this is being treated like a non-payment, right?
Your Honor, we were just considering the damages. The contract actually ended June 25th. I'm sorry, June 16th, 2025. Ms. Rancour has been residing there since that date. We were hoping that you would consider $700 per month, which was the payment she was making in the purchase agreement, as a reasonable amount for rent since that date. So that would be 7 months of rent at $700, which would be $4,900, costs of $326.80 for a total of $5,226.
I can't do that as a termination of tenancy. You gotta convert this to non-payment of rent, because that's not what I have here.
Okay. Would we be able to proceed under an unjust enrichment here, Your Honor? Because again, the contract did end.
I can imagine that it ended, but it was, the eviction was filed as
Notice to quit.
not a notice of quit. They got to do a notice of quit in both, but it was for, this is for termination of tenancy. This is not for non-payment of rent.
So we weren't sure. Again, Your Honor, this was the contract is a land purchase and sale contract.
Okay.
It was originally set up to be a purchase agreement, I guess would be the
Well,
best way to describe
I
it.
think that's absolutely.
Okay.
I exited out. Can you put it back in there, please? Are you making a motion to convert this? Is that what you're doing?
Yes, Your Honor.
Okay, and so she's been living, I guess, since the notice of quit in the property. It looks like for 7 months. June 25th until January. Without pay, is that correct? Okay. And so you've agreed to an amount of $700 a month?
That was the amount that she was paying monthly prior, Your Honor,
Okay.
but the contract is self-contained. We can't consider any of that damages, but afterwards, that's what we're hoping to do.
Sounds good. Okay, and so that's what you want to do, ma'am?
Yes.
Okay, thank you. I'll note the parties agree to convert this to a. Okay, and so the amount to retain possession would be $4,900 plus court costs $326.80 for a total $5,226.80. That's for rent through the period of the end of this month, correct?
Yes, Your Honor, but again, I'm not sure. Again, the conversion would be a problem. We were hoping to just consider it as damages. We don't want there to be a payment amount for her to retain possession.
I don't.
She's not
Possession
planning on
of the
that, but
house.
we were hoping to consider that to just be reasonable damages since the contract ended.
That's what you drafted here. If they don't play with this, that you can proceed with the eviction. So she can maintain possession of the property?
Until the 28th, yes, Your Honor.
That's not what this agreement says. It doesn't say that she's gonna vacate at all. This agreement, as you all drafted, says she can pay this or stay.
And that's, again, what we wanted to avoid, Your Honor. We did want her to try to pay.
By the 28th
Yes. And
or
again,
vacate?
yes.
Do you want me to just set this out to the 28th, see if she vacates or pays?
We would rather have an agreement in place now, Your Honor, if possible. If the
Then
damages
you're
don't
gonna have
work,
to, then you're gonna have to rewrite
that's
this
fine. I
because
have an extra copy.
this doesn't say anything about her vacating regardless. So you're expecting her to pay this
Yes,
and then vacate as well.
yes. Your Honor.
And that's not what this
I will
says.
clarify that. Thank you for pointing that out.
And then you can go ahead on this section for, we won't convert this. What we'll do is where it says rent, cross that out, put damages. And then I'm assuming what we're having here is defendant is going to pay this amount, which includes $700 per month payment of 7 months and the defendant has, says defendant to pay amount in section 2D, which includes $700 per month payment for the 7 months the defendant has resided on the premise after the expiration of the agreement. If defendant fails to pay all amounts by February 28th, plaintiff may proceed with eviction. And so I think that's where it gets,
Yeah,
Yeah.
you're absolutely
Yeah.
right. So what if I just said defendant agrees to pay the damages and vacate by February 28th? If she is not vacated,
is that what you're agreeing to do?
plaintiffs can proceed.
Can you speak up so I can hear you?
Yes, yes.
Okay, defendant
I can do it.
agrees to pay. You're gonna do that, the damages by February 28th and will vacate by February 28th. So you gotta do both of that if you want to keep this dismissed. If you just vacate, they do have the right to still have judgment entered against you, even though you vacated, but you didn't pay. You get that?
Yes.
Okay.
I do have that drafted if you'd like to take a look at it.
I'll give you that one back. I'm just gonna switch the second page, the first page, and keep the second page that has both signatures. Okay, and so, again, damages $4,900 plus court costs total $5,226.80. That you agree to pay that amount and vacate the premise by February 28th, correct?
Yes.
Okay, you understand that you have the right in this matter to proceed to trial?
Yes.
You also have the right to have a jury trial. You understand that?
Yes.
You have the right to be represented by an attorney. You understand that?
Yes.
Are you willing to give up all of these rights so that you can have this matter dismissed with the conditions we just discussed?
Yes.
Anyone coercing you to give up these rights? Okay, you have 3 business days to return to the court and request to have that set aside if you later realize you misunderstood your rights. Okay, ma'am? We may get you a copy of the paperwork. Any additional matters for the record, counsel?
No, you're fine. Thank you very
Thank
much.
you. And is it feeling what you had today?
Yes, Your Honor.
Okay, thank you.
I have 2 copies for this. That's my comment. Thank you.
Yeah, I'm getting-
You can,
Thank you. Okay, did we find Mr. Bach?
No.
See where wrong.
Okay, on the record in the matter of Todd Darwick versus Andrika Price and all other occupants 25-07-868. Appearance, please.
Good afternoon, Aaron Rollbach here for the plaintiff, Todd Dowry.
Against your Oliver P 7707 for the defendant.
Okay, today was the date that was scheduled for a hearing. This is for non-payment of rent. I do have here a consent judgment. It says that the judgment will enter by consent, rent to retain, possession $850, for court costs being $138.64 for a total of $988.64, correct?
Yes.
Okay, and that you agree to pay that or vacate no later than the 20th. That can't be right. What is today? Oh, yeah, that's right. 20th. You gave one more time. Is that accurate?
Yes, we pushed it out to the next Friday
Okay,
with
sounds
partial on the 16th.
very good. So the 20th of February, you'll pay that or vacate the premise, correct?
Yes.
Okay. It says there's also a money judgment that's going to enter. The amount of damages 121.43, plus cost 138.64 for a total of 260.07, correct?
Yes.
Defendants to pay $890 by, it says August 16th. 8/16/26.
Be 260.
Says 8, for sure.
Are you sure? Oh, you fix it?
No, I just want you to see that you definitely put 8. Okay, very good.
Somebody must have been talking to me.
That was my fault.
Okay, so we'll do 216. I'll put my initials there. And the balance by 2/20/2026, correct?
Yes.
Okay, you understand that you have the right in this matter to proceed to a trial? Do you want to waive that right?
Yes.
Anyone coercing you to do that?
No.
You have 3 business days from today's date to return to the court to have this judgment set aside if you later realize you misunderstood your rights, okay? We'll get your copy in just a moment of the paperwork. Any additional matters for the record?
Oh, Your Honor, thank you.
Nothing further. Thank you so much.
No problem. And this is Todd Dowick versus Sharmini Walker and all other occupants. She's not appeared, is that correct?
Correct.
Okay. Fault there, and then Marvin Burke, is it? Marvin Burke versus Rusty Door also failed to appear.
That's correct.
Oh, so that as well. Thank you. Were you waiting on another one? Mr. Burke, or no?
They had the call ready for Camelot versus Leighton, but then now he's here, so we're gonna go talk.
Sounds.
Yeah, yep.
That was right. I just.
Where's Jared?
Oh, he's pretty good. Yeah. They don't do that.
No. See it.
Okay, on the record in the matter of the synergy effect, care of Lansing Tree Homes versus Sharmina Swain 25-07877.
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff synergy effect.
Your Honor, Veronica Pereira on behalf of Ms. Swain.
Okay, Ms. Swain was supposed to have a hearing today for non-payment of rent. I do have a conditional dismissal. It states here that the case will be dismissed upon the condition that the defendant pays the past due rent, $4,325 plus $214.57 in court costs for a total of $4,539.57. Is that correct?
Yes, sir.
Okay, and that's for rent through a period of February 28, 2026. That's correct? Can you speak so we can hear you on the record?
Yes.
Thank you. It says defendant shall pay $865 on or before February 15, 2026, and $360 on the 20th of each month until the arrearage is paid in full. Defendant shall pay current month rent of $865 on or before the 5th of each month. While this plan is in effect. Is that complete and accurate, ma'am? Yes. Okay, you understand that you did have the right to be represented by an attorney, which you are represented by Ms. Pereira today, correct? You also have the right to have a trial. You could have demanded a jury trial. You understand that? Yes. You want to waive your right to trial today? Yes. Anyone threatening you to do that? Partial performance won't satisfy this. So that means you have to do exactly what you said you were going to do in this section here. Because if you fail to do any portion of that, the plaintiff can have judgment entered against you, okay? You will not get a new date for a court hearing if you fail to do that and they enter a request for judgment. You understand that? Do you have any questions at this time? Get you a copy of this paperwork. Any additional knowledge for the
No, thank you, Your Honor.
Thank you. Do you know sign the default form?
Oh, that was for Juanita Taylor, Olive Garden versus Juanita Taylor.
You said Olive Garden.
I'm hungry. I said
Not
Olive Garden.
Olive Garden.
Olive Garden. I'm hungry.
We saw that on the schedule and had the same thought.
Olive Garden taking people to court.
Okay, we ready with Layton?
Yes.
Okay, this is Camelot Apartments versus Zachary Layton 25-08358. Council Lieutenant.
Yes, good morning, Aaron Bach here for the plaintiff, Camelot Apartment Management Inc.
Okay, and then you are Mr. Layton, correct?
Yes, ma'am.
So Layton's got a whole pile of paperwork. He did notify that he thought he had a counterclaim. Did you file a counterclaim?
Yes, ma'am.
Okay, you received it.
We received it. I guess my goal here today is ask for time to file an answer to that and get a new date. And in the meantime, Mr. Layton and the landlord are going to speak and see if they can settle. Maybe March. Chris said he gets 14 more days to file an answer. And it looks like there's a lot of exhibits that we may need to look at, but
It's got lots of vital clips there.
yes. Yeah.
Hopefully you all work diligently.
Get that can down the road and see what happens.
Get this resolved March 4th, when?
At 9.
At 9. Do you have any questions for the court today, sir?
No, ma'am, Your Honor.
Okay, any additional matters for the record, counsel?
No, Your Honor, thank you.
Okay, we'll get your notice to appear. Thank you.
Thank you, Your Honor.
Is that all we have for the hearing? I don't have any more for my